Hey, it's your old friend Brian Parker bringing a great video on how to handle written disputes. So I'm going to show you today the average kind of letter that a consumer or debtor calls me about. This is a good opportunity if I can school or educate my clients or even you before that lawsuit comes along. This is a great way to set yourself up as a defense when that lawsuit eventually happens, using their own documents against them. So we're going to use a letter that is normally sent to you. I'm going to tear it apart so you can tear it apart and provide a defense. Why do I say you need a defense? Because if a debt collector is pursuing you, it's probably going to be suing you. I'm not being funny, but you can't spell pursue without S-U-E. And you must always have in mind that anything you say or do is going to be used against you. That's the Mini-Miranda rule, as we'll look at down the road in this video. Down the road in this video, also look for how a consumer, a client of mine, because she paid on a debt just $200, it ended up costing $10,000. So please be careful and use the documents against them, but use what I tell you if you want, the educated tools to go after the debt collector before they go after you. And of course, I'm going to give you one of my fabulous checklists that will break down everything you need to do upon receiving a letter from a debt collector. I need you to remember, when you are being pursued, you're probably about to be sued. Is it always the case? No, because there's many reasons why they don't follow up. But probably at least 50% of the time, if you're being pursued, you're eventually going to be sued. So you must keep that in your head. You're not just responding to a letter, you're responding and beating a potential lawsuit. So I want to advise you about later on in this video, at the end of this video, and again, I know people will say, hey, let's go to the end, and then so you'll have a complete view. But that's when my silly script came up. I have a client that because of $200, it's cost over $10,000 to fix. So let's look at, to start this off, what I'm going to show you is probably 99% of the letters debt collectors send out. There are those debt collector law firms that don't use this particular form. This was presented in 2021 by the CFPB saying, hey, debt collectors, if you use this letter, you're likely not to be pursued for debt collection violations, and they called it a safe harbor letter for debt collectors. And I've railed against this many times because I think it's actually helping debt collectors rather than helping you. The FDCPA, the Fair Debt Collection Practices Act statute, is designed to regulate debt collectors, not debtors. The debtor is unsophisticated and is facing a corporate entity that's done this a million times. That's why the statute is one-sided, to protect a debtor. This seems to protect, when I point, I'll show you. The letter that the CFPB said, hey, debt collectors, follow this safe harbor letter, you'll be safe. It seems to hurt consumers, which is not the point. It's supposed to regulate debt collectors. So let's take a look at that letter that you may recognize. Shazam. That's the format of every debt collection letter, 99% today, as of November 30th, 2021, when they came up with new rules on the FDCPA. So I'm going to break down what this says and how you can use it to your advantage, all right? From my 30 years of doing this and just every aspect again and again, I see this stuff in my sleep. So let's break down and look first at that's the letter. So I'm going to break down parts of it that you can use for you. So while you're being pursued, remember, you can't spell pursue without S-U-E. So their pursuit of you can either mean they're coming after you, or the way they pursue you means you can sue them for the FDCPA violations that inevitably occur. So let's look at the first section is the address. It says North-South Group. That's a made-up debt collector for the purpose of showing debt collectors how their letter should be. So that's the address, the P.O. Box. P.O. boxes that are the bane of my existence, meaning I have to make sure that someone signs for a letter, either for my client sending a letter or me. Real quickly, I'm engaged in this one heavy litigation where they keep claiming they never received it because I send it to a PO box. And I try to send it certified, and it just causes problems when you're sending something to a PO box. So what I do is I do this, and I do this to the law firm. That drives them crazy too. So when you see a PO box, just assume that that's a negative. That's bad for you. They say they want you to send them something, then they give you a PO box. Who knows where that goes? So what I want you to do is remember, never use this address. Find out the name of the debt collector, say, and you can just Google this. What is the corporate address? Confirm that that's it, and then send everything to the corporate address. Again, this letter seems designed to knock the debtor off course and put them in a small box. And remember, I just said that because this is all about a small box. So here is the way they've categorized or stated the person they're suing. So, or not suing yet, but sending a letter. So here's the address of you, let's say. It says person A, 2323 Park Street, apartment, blah, blah, blah. What if that's not your address? Commonly, especially with debt buyer cases, they use the wrong address or the wrong name, and they end up putting the lawsuit on the door and 21 days later defaulting my client that doesn't know this is going on because they moved from that place for a divorce or just moved on 6 years ago. Now they learn they've got a default. So do you want to give them the right address? And the answer for me and my clients, and everybody can do whatever they want to do, is do not help them in any way, shape, or form. We're accommodating people. We want to help in a sense. Don't. There's a fiction here that you have to keep going. If it's a debt buyer, the information they receive is sometimes 5 to 10 years old. While you don't want to suffer a default, you also don't want to face a lawsuit with the right information and less defenses. It's not your job or duty to tell them the right information. They're pursuing you. So if they want to even say your name is wrong because you've moved on, divorce, or that's your maiden name, just when you seek information, you're going to be putting on your letter, I'm listed as Bob Jones, such and such address. Don't help them in any way because it doesn't benefit you. There's no utility. What's the benefit for you? So here's the rule on disputing debt. So the rule in a nutshell is once you send a written dispute, you cannot be pursued until they validate the debt. And again, this letter that the government has said, hey, debt collectors use, eats at that too. And I'm going to show you how. But the debt collector shall cease collection of the debt or any disputed portion thereof until the debt collector obtains verification of the debt or a copy of a judgment on the name and address of the original creditor and is mailed to the consumer by the debt collector. So if you give them the right address, they're going to give you that stuff at the right address. But what's the benefit? Now they can go really pursue you. If they continue on their course of the wrong address, they will keep going. It's sort of a tricky move, but if they keep pursuing you at the wrong address and they say, hey, we sent you the stuff, but you didn't receive it because you're 5 years down the road, and they keep calling, now you have a lawsuit against them. But Parker, shouldn't you tell them the real address? No, I didn't tell them to call me. They haven't proved they own the debt. My job isn't to help them prevent a lawsuit because it's very easy to find my address. Just go to the white pages, just Google, and if they haven't done that, that's on them. And their system is set up so that they don't do that kind of work if it's a debt buyer case. There's no money in it for them. So remember, you're not under a duty to correct them if they're relying upon bad information. Along that vein, you will see in this letter, let me just put the letter again, the section that bothers me. Shazam, North-South Group is a debt collector. We're trying to collect the debt that you owe to Bank of North Rockville. We will use any information you give us to help collect the debt. Okay, so that's what is commonly referred to as the Mini-Miranda. That's the version that they're showing you of the Mini-Miranda. I would argue it's not the proper notice, and without validation of the debt, there is no proof you owe the debt. So why are they saying, and I quote, collect a debt that you owe to Bank of Rockville on the same letter advising you that you have rights to seek proof of whether the debt collector does have the right to pursue. It's a bit disingenuous, I think is the word. I'm not going to say what I really want to say. It's a minor point, but it's not the Mini-Miranda that debt collectors are supposed to use. And this is the government, again, getting it wrong. You need to hit them on everything, because down the road, remember, if they're pursuing you for a debt, it's probable that they are going to be suing you for a debt. So don't make it easy. It's not, you have no duty to do that. So here's how it should be. The Mini-Miranda on most law firms use this. Shazam. This is an attempt to collect a debt, and any information obtained will be used for that purpose. That presupposes nothing. It doesn't assume you owe the debt. It just says, this is an attempt to collect a debt. Anything obtained will be used for that purpose. Remember, used. This presupposes nothing. At the same time, the collector is adequately following the law. Let me give you the 99 out of 1,000 Mini-Mirandas that debt collectors use commonly, either on lawsuits and in letters. Shazam. This is a communication from a debt collector. We are attempting to collect a debt, and any information will be obtained will be used for that purpose. Remember that last section. So here, they're telling you, Shazam, where to mail this form. This letter, now they're categorizing as just a form. And again, mail to the debt collector's corporate address or to the debt collector's main address. And always, as I always say, register by mail, keep a paper trail. You send it certified, you'll get a green card back showing they signed for it. That saved my clients so many times. I was trying not to curse, so I messed up my words. But having them sign that, because most offices, the secretary signs. Now the person pursuing you doesn't know half that stuff that the secretary is signing for, and it's a good thing. So you'll commonly see the information flow down to a new debt collector or a lawyer. They did not validate this debt, and they have done that. So you can go after them if you have that green card showing, hey, you kept pursuing me, you signed for this, you know that I sent your validation. The law says, when I dispute in writing, you cannot pursue me. So now here's the stuff that bothers the hell out of me, right? So how do you want to respond, the letter says. Let me show you that. Shazam. I want to dispute the debt because I think this is not my debt. The amount is wrong. Other, please describe on the reverse. Okay, you have rights under the federal law. The Congress sat down and went over this for months to make sure you got proper notice in regulating debt collectors. Now, this letter created by the CFPB is saying, check a box, this is not your debt. I call bullshit on that, okay? The letter is notice required under your rights to properly advise you what a debt collector must prove to continue to contact you. In a nutshell, do not check a box when receiving your Congress-driven federal rights, okay? Here again is the federal rule on what a debt collector must provide you to prove they have the right to pursue a debt. It's not a box to check off. So it's quite long, but I'm trying to make a point here. Here's the rule. They got to give you the amount of debt, the name of the creditor, a statement that unless the consumer within 30 days after receipt of the notice receives the disputes the validity of the debt or any portion thereof. Number 4, a statement that if the consumer notifies the debt collector in writing or any portion it is disputed, you can't chase this person. You've got to obtain a verification they have the right to pursue you. 5, a statement upon the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor. One of the reasons why that letter requires so much is because, in a sense, it shakes up the other side going, oops, we have pursued this person with the wrong address, the wrong. It is a notice that says, hey, debt collector, are you sure you're pursuing the right person? So if you looked at all the letters that I give my clients, they always say, do you have the right person? That's huge because the Fair Debt Collection Practice Act is protecting the debtor while regulating the debt collector. So they will keep going. If you're notifying you have the wrong person, that's heavy notice to them that they better take a look at the information they're using. And that's your duty, is to follow the law also and say, do you have the right person? So take control and send a proper full-scale demand that seeks everything. So that's actually to a big debt collector, Stenger, Citibank debt, and they had written the Mini-Miranda right on the complaint. So that's a debt collection communication. So I said, hey, you're a debt collector, Citibank, and the rules bear that out. And you can see, I received a debt collection letter from you. Do you have the right person? Court cases really key in on that. If you say, hey, they sent me a debt collector letter and it was the wrong amount, the courts are gonna go, yeah, all right, it's a minor inconvenience. But if the wrong person, wrong address, wrong information is being used, the courts look at that because you're entitled to notice. So I look the name and address, the original and current creditor, the verification of the debt, the contract signed with the original creditor, securitized. Was this securitized? I want to know the process. So my letters go deep. You can see this is a Michigan letter, and in Michigan there's a little state statute that says you have to provide the debtor every payment they made, when and where, right? So most debt collectors don't realize that. They ignore the state rules so that you can get them that way. And also this important part about what this whole thing is also centralized on, which is the Fair Credit Reporting Act. How is the debt being reported by this collector that claims they owe the debt? Are they reporting it before they even prove they have a right to pursue you? So please provide me with a proof of why you have permissible purpose to contact my credit. It's something that you can sue them on, just that couple of words. If you pass this on to another collector, please advise a new collector that I dispute the debt. There's sufficient case law that says if the original debt collector passes this on and doesn't tell the other side about the dispute, they're both on the hook, depending on what notice the new creditor, the new collector gives you. So have that in, that's my letter, is what I'm saying. So do you want to check a box? Or let's put my letter up there again, Shazam. Or do you want a full-scale pursuit of your rights under the Fair Debt Collection Practices Act? I think it's quite obvious. So don't get put into a box the way the CFPB has done. So I got a question for my audience. Do you want to just click a box, or do you want to make a debt collector honor the federal rights that Congress gave you? So here's another thing that bothers me. I enclosed this amount. Make your check payable to blah, 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 blah. Why are you paying anything on a letter that says, send us a letter, a request to prove we have a right to pursue you, that you owe the debt? Who told them? No letter should say that, that's authorized by the government to debt collectors. First, let's find out who are they chasing? Do they have the right person? And then we can talk about money down the road depending on the proof. But why would you send money without making them prove they have a right to collect upon you? So I think the law categorizes as the debtor as an unsophisticated person. They're not making judgments, but compared to the machine of a debt collector, cases, courts refer to the debtor as an unsophisticated consumer. That's a legal term of art. They're not casting aspersions. They're saying compared to the machine and company that does this for a living, these guys are unsophisticated. They require our protection. My clients, you consumers, require a protection. So to just say, and without, just send us a check. No, you've got to give people their rights and tell them why they don't owe the debt unless they properly validate. And all this has legal consequences down the road. Again, look for down in the video towards the end, the $200 mistake that cost thousands of dollars, all right? So this is another thing that bothers me, and it should bother you. I'm gonna tell you why. Here is our information shows you had a Main Street department store credit card from Bank of Rockville, and it lists what they claim you owe and why. Good, but that's not what debt collectors generally do. When you send these verification letters in writing, you will commonly get back proof that contradicts this original letter. That's legally significant if you are pursued for debt. And in the interim, you've made payments, something has happened, you've been given credit for something, So if you can show contradictory requests, that can only benefit you if you're being sued, or the fact that they don't have the right information to pursue you. So here's what I see in debt collection letters. This happens, all right? So let me put this up there. Here's an example of a debt collector adding on fees and charges. This is a case that I'm litigating right now, and I've put an orange. They're seeking $199.50, and they categorize it as you were charged this amount in fees. That's the debt collector saying, hey, we need an extra $200. So then they can up the amount supposedly that you owe. So that's the debt collector increasing its percentage, the amount it can collect for sending this letter. Were you to send a check in for the full amount, they'd get more money because they bumped it up. So that is a common thing. I used to do a lot of class actions, especially against debt collectors pursuing people for private student loans. They throw on a third or 25% as their charges. And courts generally said, how have you earned that 25% or that third? What have you done? And so the rule is, here's the rule. It's 15 U.S.C. Code 1692F. F is a serious one. A debt collector may not pursue unfair or unconscionable means to collect or attempt to collect any debt without limiting the general application of foregoing. The following conduct is a violation of this statute. This is one of like 8 sections. So the first is the collection of any amount, including any interest, fee, charge, or expense incidental to the principal obligation, unless such amount is expressly authorized by the agreement creating the debt. Meaning, what does the contract say you're allowed to pursue? Like a lot of times it'll say, a debt collector will pursue you, it's entitled to its reasonable fees and costs. Or a debt collector will pursue you, it's entitled to 25%. If you signed off on that, then they have an authorized agreement to seek a certain amount. You signed off on that. And there's exceptions to that, but that's the general rule. So remember, here's the general rule for you. Debt collectors cannot collect any amount beyond what you originally owed unless it was specifically written in the original agreement. State and federal law allows it. I won't get into that, but there's other instances where they can collect something, in a sense, overruling the contract, but it isn't relevant here, and it's a very minor thing. That is why you have to write your own letter and not check a box or send in a check. Make them prove it. So my letters demand the original contract, challenge unauthorized fees, know your state laws. I filed many a class action on 15 U.S.C. 1692F. Okay, and now there's another section. How can you dispute the debt? Call us or write, dispute in part. If you write to us by August, in this case, August 28, we must stop collection on any amount you dispute until we send you the information that shows it. Dispute it all, not on any amount that you just, that's kind of not the rule. Question, who says the information shows you owe the debt? They do. That is why you challenge them with a much deeper letter, my letters, requiring of the information to prove you owe the debt and not just the determination of the debt collector. So in a sense, I don't want you believing anything they say. That's a great lesson for you right there. So you want to know about the $200 mistake that cost thousands of dollars? Okay, so a client gets sued by Velocity. What she did is, like it's a normal thing, called up the debt collector. Do you have the right person? Da da da. They go, you owe this. We're suing you. Blah blah blah. And for some reason, and it's common, if you just pay a little, we know you're going to show good faith here, and that way we can, we'll back off. They never do. So she said, well, here's $200. I don't know who you are, but here's $200. So this is gone up to the Court of Appeals a couple of times now because, this is what I have to read every time in their responsive briefs. Shazam. This is just the defendant's action. Just like the defendant's actions at the case of bar, defendant appellant's assertion, appellant means we've appealed it, it's in appeal now, ring hollow and appear disingenuous. The defendant knew the plaintiff Velocity was the assignee of her debt. She didn't, she's just scared out of her mind. On April 4, 2023, the defendant entered into a loan payment agreement with plaintiff and made a payment of $200. I hear that on every motion up and down the Court of Appeals and Circuit Court. I've got to hear that. By the way, payments don't mean they own it. but it shows a lot of judges that go, well, I guess she owes it and she paid it. So I've got to, that's more work I've got to do. You know, I've put in over $10,000 of my time defending that because of that $200 that normally we just settle for a little debt elimination. So all this is on Killdebt.com. Use Parker GPT, it's all embedded. Attached to this video will be validation letters for you, cease and desist letters, show notes, a checklist on what you can do with collection letters and handling verbal context. So you know I love my checklist. My checklists are for you. That'll be embedded in Parker GPT too, but use that checklist. You can have it right next to you when you know you're receiving calls or if you receive a letter. Let's take a look at Parker's checklist. It works for you, but go to Parker GPT. It's less than 1/10 of what you'd pay an attorney to defend these things, because defend these things you will if you don't do the right thing. And even if you do 100% of the right thing, you still may be pursued. But now you've got all this great evidence because you did the homework. You followed Parker's rules on handling debt collector letters and calls. I hope this helps. You're the best.